After studying this module, you will be able to understand the structure of Indian policy on research and development, gain knowledge about the Indian Patent Act, understand the legal aspects related to patents, analyze the concept of technology transfer and its modes, appreciate the role of technology transfer in economic development. In today's dynamic world, there is no place for stagnant economies. Therefore, to survive in the world market, each business needs to be very active in terms of research and development. Research is the new buzzword in business, where each organization is striving to achieve something new and better than the competitor to attract new customers and retain the old ones. This chapter deals with the research and development policy of India and patent laws as legal framework for protecting the technology. This chapter will also explain the need of technology transfer and why technology transfer is important for the developing economy. Let us now understand policy on research and development. The economies of present-day world are driven by scientific research and technology. In India, the resolution on science policy was adopted in the year 1958 to put thrust on this direction and led to foundation of a strong scientific and technological infrastructure in the country. It includes setting up of a chain of national laboratories. Some of them are: number 1, Council of Scientific and Industrial Research, that is CSIR; number 2, Indian Council of Agriculture and Research, that is ICAR; number 3, Indian Council of Medical Research, that is ICMR; number 4, Defense Research and Development Organization, that is DRDO; number 5, Department of Atomic Energy, that is DAE; number 6, Department of Space, that is DOS; and number 7, Department of Electronics, that is DOE. Apart from setting up of national laboratories, also includes many other specialized R&D centers, universities, IITs, and various academic institutions that continuously provide different functions, such as: number 1, they provide expertise; number 2, they provide technical training to manpower; number 3, they provide technological support to industries. In the formative years, Indian industries were totally dependent on imports for technology and scientific and technological, which in turn facilitated rapid assimilation and indigenization of such technologies. Continuous measures have been initiated with time to meet the dynamic and continuously evolving industrial and technological requirements of a developing country like India. The objective of science and technology policy of the year 2003 was: number 1, to achieve coordination between industry and scientific research; number 2, to encourage the transfer of technology and know-how generated by scientists and technologists to industry. The policy Science and Technology also encourages, through innovative mechanisms, investments by industry in education and research and R&D, either in-house or through outsourcing. As per the guidelines given by UNESCO, the Department of Science and Technology (DST) has been undertaking benign national surveys on a regular basis since 1973-74 on resources devoted to scientific and technological activities. As per the Directory of R&D Institutions 2006, that is in August, published by the Ministry of Science and Technology, around 3,960 R&D institutions are classified as follows. Number 1, Central Government R&D Institutions 707, public sector includes only 115 in-house R&D units of central public sector undertakings. Next, state government institutions, which are 834, universities, deemed universities, and 284 institutions of national prominence and importance. Private sector includes in-house 2020 R&D units of private sector, industries and scientific and industrial research organizations recognized by DSIR that totaling up to 3,960. Let us now understand the importance of R&D in India. Research and development is an invaluable tool for growing and improving the business sector of a country. R&D involves researching market areas and needs of customers to develop new and improved products to satisfy the needs of customers. Businesses having well-established R&D, infrastructure and strategies have a better chance of success as compared to businesses that do not have. A good and powerful R&D strategy can lead to innovation and increase productivity and can boost your business competitive advantage. Since size of a business has great impact on the nature of R&D strategy as explained by figure given below. Due to the budget and cost constraints, the small businesses normally focus on product improvement. On the other hand, as large businesses have the availability of huge financial resources, they can dedicate R&D activities for the creation of a new product as well as focus on the improvement of existing ones. One thing needs to be understood by the businesses that spending too much money on R&D is not a guarantee of success. The key to successful R&D is extensive market research. Market research is a tool to identify the unsatisfied needs and wants of a customer. Let us now understand the Patent Act. As per Patent Act 1970, patent is defined as a monopoly right which is granted to a person who has invented a new and useful article or an improvement of existing article or a new process of making an article. Patents give an exclusive right to manufacturer of article product for a limited period. Inventories can be divided into number 1, product inventions. When a new product or new alloy is invented, it is known as product invention. In this situation, patent is referred to as product patent. Number 2, process invention. When the new processes to produce a commodity are invented, it is known as process invention. This is referred to as process patent. Patent Act, process patent and product like food, pharmaceuticals and chemicals, the inventors were granted only EMR, that is exclusive marketing rights. In India, patent system is administered under the superintendence of the Controller General of Patents, Designs, Trademarks and Geographical Indications. The functioning of a patent office and patent information system is directed by the Controller General, like granting patent for new inventions, etc., is performed by Patent Office. The head office of patent is located at Kolkata and 3 other branches are located in Mumbai, Chennai and New Delhi. The duty of branches is to deal with the applications of patents corresponding to their territorial jurisdiction. The patent related information and specifications is maintained by Patent Information System and also provides technological information to various users such as R&D establishments, government offices, private industries, business and inventors. Let us now know legal aspects related to patents. The main provisions of the Patent Act are as follows. Number 1. The Controller General of Patents, Designs and Trademarks appointed under the Trade Merchandise Marks Act 1958 shall be the Controller of Patents. For the registration of patents, Patent Office is maintained. A register of patent is kept at all patent offices, which includes A. The names and addresses of grantees of patents. B. Notifications of assignments, extensions and revocations of patents. And number C. Particulars of such other matters affecting the validity or proprietorship of patents as may be prescribed. An application for a patent for an invention may be made by any of the following persons. By any person claiming to be the true and first inventor of the invention. Next, by any person being the assignee of the person claiming to be the true and first inventor in respect of the right to make such an application. Next, by the legal representative of any deceased person who immediately before his death was entitled to make such an application. The following are not inventions within the meaning of Patent Act. A. An invention which is frivolous or which claims anything obvious contrary to well-established natural laws. B. An invention, the primary or intended use of which would be contrary to law or morality or injurious to public health. C. The mere discovery of a scientific principle or the formulation of an abstract theory. D. The mere discovery of any property of new use for a known substance or of the mere use of a known process, machine or apparatus, unless such known process results in new product or employs at least one new reactant. E. A substance obtained by mere admixture resulting only in the aggregation of the properties of components thereof or a process for producing such substance. F. The mere arrangement or rearrangement or duplication of known devices, each functioning independently of one another in a known way. G. A method or process of testing applicable during the process of manufacture for rendering the machine, apparatus or other equipment more efficient or for the improvement or restoration of the existing machine, apparatus or other equipment or for the improvement or control of manufacture. H. A method of agriculture or horticulture. Number 1. Any process for the medicinal, surgical, curative, prophylactic or other treatment of human beings or any process for a similar treatment of animals or plants to render them free of diseases or to increase their economic value or that of their products. One single application is to be given for one invention and shall be made in the prescribed form and filed in the Patent Office. Every application shall state that the applicant is in possession of the invention and shall name the owner, claiming to be the true and first inventor. And where the person so claiming is not the applicant or one of the applicants, the applications shall contain a declaration that the applicant believes the person so named to be true and first inventor. Every such application shall be accompanied by a provisional or complete specification. Where an application for a patent, not being a convention application, is accompanied by a provisional specification, a complete specification shall be filed within 12 months from the date of filing of the application. And if the complete specification is not so filed, the application shall be deemed to be abandoned. Every complete specification shall A. fully and particularly describe the invention and its operations or use and the method by which it is to be performed. B. Disclose the best method of performing the invention which is known to the applicant and for which he is entitled to claim protection. And lastly, C. End with a claim or claims defining the scope of the invention for which protection is claimed. At any time within 4 months from the date of advertisement of the acceptance of a complete specification under this Act, or within such further period not exceeding 1 month in aggregate as the controller may allow, or application made to him in the prescribed manner before expiry of 4 months aforesaid, any person interested may give notice to the controller of opposition to grant of patent or any of the following grants, namely, A. That the applicant for the patent or the person under or through whom he claims wrongfully obtained the invention or any part thereof from him or from a person under or through whom he claims. B. That invention so far as claimed in any claim of the complete specification has been published before the priority date of the claim. In any specification filed in pursuance of any application for a patent made in India or after the first day of January 1912 or in India or elsewhere in any other document. C. That the invention so far as claimed in any claim of the complete specification is claimed in a claim of a complete specification published or on expiry the priority date of the applicant's claim and filed in pursuance of an application for a patent in India being a claim of which the priority date is earlier than that of applicant's claim. D. That the invention so far as claimed in any claim of the complete specification was publicly known or publicly used in India before the priority date of that claim. E. That the invention so far as claimed in any claim of the complete specification is obvious and clearly does not involve any inventive step. F. That the subject of any claim of the complete specification is not an invention within the meaning of this Act or is not patentable under this Act. G. That the complete specification does not sufficiently and clearly describe the invention or the method by which it is to be performed. 8. That in the case of a convention application, the application was not made within 12 months from the date of the first application for protection for the invention made in a convention country by the applicant or a person from whom he derives title, etc. Where any such notice of opposition is duly given, the controller shall notify the applicant and shall give to the applicant and the opponent an opportunity to be heard before deciding the case. Where a complete specification in pursuance of an application for a patent has been accepted and either 1. The application has not been opposed and the time for the filing of opposition has expired. 2. The application has been opposed and the opposition has been finally decided in favor of the applicant. 3. The application has not been refused by the controller by virtue of any power vested in him by the Act. Then the patent shall on request made by the applicant in the prescribed form be granted to the applicant or in the case of a joint application to the applicants jointly and the controller shall cause the patent to be sealed with the seal of the Patent Office, and the date on which the patent is sealed shall be entered in the Register of Patents. The term of every patent granted and the term of every patent which has not expired and has not ceased to have effect under this Act shall be 20 years from the date of filing of the application for the patent. Where an application is made for a patent in respect of any improvement in or modification of an invention described or disclosed in the complete specification filed thereof, and the applicant also applies or has applied for a patent for that invention or in the patentee, in respect thereof, the controller may, if the application so requests, grant the patent for improvement or modification as a patent of addition. A patent of addition shall be granted for a term equal to that of the patent for the main invention. At any time after the expiration of 3 years from the date of sealing of a patent, any person interested to make an application to the controller alleging that the reasonable requirements of the public with respect to the patent invention have not been satisfied, or that the patented invention is not available to the public at a reasonable price, and praying for the grant of a compulsory license to work the patented invention. If any person fails to comply with any direction given under the Act, or makes or causes to be made an application for the grant of a patent in contravention of the Act, he shall be punishable with imprisonment or with fine or both. Let us now understand the meaning of technology transfer. To understand the concept of technology transfer, a brief description of technology can also be given. In the words of Kumar et al. In the year 1999, technology consists of two primary components. Number one, a physical component which comprises of items such as products, tooling, equipments, blueprints, techniques and processes. Number two, the informational component which consists of know-how in management, marketing, production, quality control, reliability, skilled labor and functional areas. It can be easily found that technology used in developed countries is different from that used in developing countries. But developing countries need updated and advanced technology for faster economic development. In an era where world has become global village, product of each and every country, whether developed or developing, is competing with each other. In this kind of scenario, it becomes more important for developing countries to make technically sound product that faces competition from developing countries. This situation creates scenario for technology transfer. UNCTAD has requested to developed nations to transfer technology to developing nations. In simple words, technology transfer is a price by which commercial technology is transferred by one proprietor or firm to another firm. This transfer can take place between the following. Number one, developed and developing nations, developed and developed nations, developing and developing nations. In the words of WIPO, the dissemination and transfer of technology is major pillar support to raise the centers of patent system. Patent gives an exclusive right to improve the efficient flow of knowledge and also facilitate to protect the technology. It is a legal framework that gives a platform to all technology holders to present their inventions to general public and also provide them an opportunity to sell their patent. The process of technology transfer is complex and number of factors such as political, market, human resource, etc. affect process of technology transfer. Any conflict with the economic and social needs of the recipient country will affect the success of technology transfer. For instance, in the year 1960 or in the 1960s, the agricultural development of northeastern Brazil was mainly financed by international banks or financial organizations. But much of this region had been inhabited by Brazilians, aborigines, but in the tropical rainforest area like Amazon, imported technology caused serious environmental damages such as soil erosion and also resulted in the destruction of natural environment of birds and animals. Therefore, it is imperative to check the suitability of technology and its expected effects of different factors before actually starting the process of technology transfer. So, it is to be understood that technology transfer concept is not only a matter of concern about the transfer of technological knowledge or information, but also the capability of technology recipients to learn and absorb technology into the production function. Thus, in the year 1987 argues and explained that technology transfer can be of following two types. Number one, product or embodied technology transfer that refers to production. Number two, process or disembodied technology transfer which refers to improvisation in production processes to maintain efficiency. Figure 2. Types of technology transfer. Number 1. Production of new product or embodied technology transfer. Number 2. Most efficient production of existing products, that is processes or disembodied technology transfer. As described by Levin in the year 1993, in the social science perspective, technology transfer is a socio-economic process implying the transfer of cultural skills accompanying the movement of machinery, equipment and tools. Let us now understand the various types of technology transfer. Broadly, transfer of technology can be of two forms. Number 1, internalized technology transfer, and number 2, externalized technology transfer. Let us now understand the various levels of technology transfer. Number 1, the operational level. It is the least possible level of technology transfer. It may take place in the forms like manufacturing skills, maintenance, procurement or quality control. Next is the duplicate level. Next level in the technology transfer can be duplicate level, where investments are also made to increase the level of capacities and to purchase and integrate foreign technologies. Next is the adaptive level. This level is a level of self-reliance where imported technologies are adapted and improved according to the requirements of locals. Then we have the innovative level. This level of technology transfer is a symbol of innovative skill based on well-established R&D, which is an essential to generate new technologies. Let us now know types of technology transfer agreements. The first one is the license agreement. A license agreement is one of the most detailed agreements of the technology transfer. The license agreement includes the following: B. Training to employees. Knowledge of simple and unpatented techniques or production process can be transferred by imparting training to personnel. C. Turnkey contract. Route of turnkey project is normally taken to the transfer complex technologies. Apart from supply of goods, it includes design, creation, commissioning or supervision of a system of client. D. Contract for the sale of plant and machinery. It provides for the transfer of operational technology pertaining to the plant and machinery being transferred. Let us now understand role of technology transfer in economic development. As per the old proverb, give a man a fish and you feed him for a day. Give a man a fishing rod and he feeds himself and his family for as long as the rod lasts. But a new take on this old proverb can be, help a man develop the knowledge and means to improve the fishing rod and to design and produce new ones, and he may feed himself and his society for years to come. This new adaptation of old proverb given by WIPO clearly explains the role of technology transfer in the economic development of any country. This is a huge technological gap between the rich and poor countries, and the main reason behind this gap is economic distance between these two areas, as pointed out by Lord Snow in his Two Cultures. And a second look, the improvement in the level of living in the developing countries does not require any major new scientific discoveries. The accumulated knowledge is sufficient to accomplish this task. What is needed is to ensure its transfer to the needy. In the 19th century, when process of industrialization began, each new nation which started industrialization process either bought, borrowed or stole the technical knowledge. As a result of such transfer of the overall growth rate of the world was progressive. So, transfer of technology performs central role in the development of nations. Development of a country depends upon the goods and services produced, which in turn depends on the availability of technology. It is imperative for every country to use best and updated technology to maintain the pace of growth. If a country cannot innovate or produce technology itself, in that case technology transfer can play a very important role. Students, let us now recapitulate what we have learnt in this module. The economies of the present day world are driven by scientific research and technology. In India, institutions such as CSIR, ICAR, ICMR, DRDO, DAE, etc. have been established to conduct research activities. The objective of science and technology policy is to achieve coordination between industry and scientific research and to encourage the transfer of technology and know-how generated by scientists and technologists to the industry. Businesses having well-established R&D infrastructure and strategies have a better chance of success as compared to businesses that do not have. A good and powerful R&D strategy can lead to innovation and increase productivity and can boost your business's competitive advantage. Patents give an exclusive right to the manufacturer of article or product for a limited period. In India, patent system is administered under the superintendence of the Controller General of Patents, Designs, Trademarks and Geographical Indications. Technology used in developed countries is different from developing countries. but developing countries need updated and advanced technology for faster economic development. Patents give an exclusive right to improve an efficient flow of knowledge and also facilitate to protect the technology. Patent is a legal framework that gives a platform to all technology holders to present their inventions to general public and also provide them an opportunity to sell their patents. There can be two types of technology transfers, that is, internalized technology transfers and externalized technology transfers. Level of technology can be operational, duplicate, adaptive and innovative. Technology can be transferred through agreements like license, training to employees, turnkey contract and sale of plant and machinery. Transfer of technology performs central role in the development of nations. Development of a country depends upon the goods and services produced, which in turn depends on the available technology.